Thank you very much for joining the Landmark Chamberlain's webinar on cost for planners. So we're delighted that so many people have joined the session today, and we hope that you will find the presentations and discussion useful and informative. My name is Tom Morris and I will chair the panel today. I'm joined by my colleagues Rupert, Cohen and Nick Grant, whom I will formally introduce in a moment. To begin with, a few housekeeping points. Your microphones have all automatically been muted, I'm afraid, so you will not need to adjust any of your settings. We do welcome questions throughout the session, but please submit these in the text, via text in the question and answer section, which can be found, I think, at the bottom of your screen. And at the end of the presentations, we will endeavour to answer as many of those as possible. This webinar is being recorded and you will receive a link to the presentation afterwards and shortly after the event concludes. If your connection is lost at any point during the webinar, then we invite you just to rejoin the meeting by clicking again on the original link which was sent out. So that concludes the housekeeping. Let me just introduce my colleagues. Nick Grant, who will be speaking first, is a junior barrister at Landmark, practicing in planning and costs and property law, and to whom, it should be said, all the credit for this webinar is due because it was his idea. He joined Chambers in 2019, and his recent work includes promoting the world's first tidal stream technology development zone off the coast of Anglesey, as well as acting unled in a number of major planning inquiries, including resisting energy from waste plants and a 20-storey tower block in Ealing. And he is also involved in the Heathrow litigation in the Court of Appeal. And his costs practice involves regular appearances in detailed assessment hearings and also advising on all matters of cost law, including on quantum. Rupert Cohen, who will speak last, is a very distinguished cost barrister as well as a property litigator. He's appeared in numerous costs appeals in the Court of Appeal, the High Court and the Senior Court's Costs Office. He's a member of the Attorney General's B Council, in which capacity he's instructed on numerous important cost appeals. And he and I should say as well, have also been instructed on the ongoing detailed assessment of costs arising out of a trial in 2013 between Deutsche Bank and Sebastian Holdings Inc., which involves the assessment of tens of millions of pounds of solicitors' costs. And also, we think the largest disbursement ever assessed being a claim for the costs of forensic accountants running into the tens of millions of pounds as well. My practice, I should say, just briefly to introduce myself, is also in cost law, as well as planning and in property litigation. Nick is going to deal with the costs awards in the context of planning appeals. I will then deal very briefly with some of the procedural points for detailed assessments, and also a couple of interesting points of law relating to the costs of experts. And Rupert will deal then finally with the all-important issues of reasonableness and proportionality, and we'll also have a look at how the cost of the assessment gets recovered. So without further ado, I will now hand over to Nick.
Thank you, Tom. Hello, everyone. My job today is really, as Tom said, to set the scene when it comes to planning costs. I'll look at how and when an award may be made, and then a little bit at how that connects with the standard costs regime that's used up and down the country for every set of proceedings. So starting planning matters, and that jurisdiction arises out of section 255 of the Local Government Act 1972. And I've put the wording of part of that up on your slides. That power, which initially is given to the Minister in planning inquiries, has been extended to inspectors and now to hearings and written reps, not just to inquiries. This doesn't necessarily apply to all inquiries, hearings or written reps whenever they occur. It does cover the majority of sort of TCPA planning matters, so planning appeals, enforcement appeals, cleareds, cloppards, tube preservation orders, etc. And it does include aborted inquiries. But if you're dealing with something a bit more complicated or under different legislation, you'll need to check that legislation. So for example, I recently did some work on the EIA Assessment Agriculture England No. 2 regulations 2006. And that's one where if you only do matters via written reps, there's no clear costs jurisdiction. Also be aware that the Secretary of State who causes an inquiry to be held may recover his administrative costs of so doing, including if an inquiry is aborted. So that's That's kind of the legislative framework for costs. And the Secretary of State, given that it is his power, has published a policy on the award of costs in the PPG, which, for those who've been in practice, or this bit for those who've been in practice for a long time, replaces Circular 7365. As this is a Secretary of State policy, his inspectors must apply it. And it's made very clear in Swale that they err if they don't. So there are two limbs which have to be satisfied for the Secretary of State to have discretion to award costs. First, a party has behaved unreasonably, and second, that unreasonable behaviour has directly caused another party to incur unnecessary or wasted expense. So costs in this jurisdiction don't follow the event. By that I mean they're not automatically awarded just because you won the appeal, and they can in fact be awarded against a successful party. That's kind of not the rule that one sees in standard litigation, but it is the rule we get in planning inquiries. The purpose of this costs regime, again as is set out in the PPG, is to encourage parties to pay reasonably, encourage LPAs to properly exercise their development management responsibilities, and discourage unnecessary appeals. So basically it's there to make sure the parties behave sensibly. If a costs award is made, it may be full or partial. A full award, unsurprisingly, relates to the entire costs of the statutory appeal process. Partial costs relate to a part of it. So it may be one ground, it may be a wasted day, it may be a wasted witness, or what have you. Against that background, I'll look a little bit in more detail at the two limbs. Starting with unreasonable behaviour. Unreasonable in this case is used in its ordinary meaning. It's not what lawyers recognise as kind of Wednesbury type unreasonableness. And unreasonable behaviour can be either procedural or substantive. So procedural behaviour can include things like failing to meet deadlines, witnesses failing to attend, failing to prepare, resulting in an adjournment, failing to resolve statements of common ground, or, and this is one that I've seen, trying to introduce wholly new technical evidence halfway through an inquiry, which nobody was prepared for. Just pausing briefly on this procedural side, because in public inquiries we see a lot of interested parties or indeed aggressive developers taking part, there can be a tendency to watch a few too many courtroom dramas and want to imitate that aha moment where new evidence is introduced that leaves everyone gobsmacked. That's really, really not how planning inquiries and planning appeals work. All parties should have an adequate chance to look and understand the other side's evidence and respond. And some members of the public, some developers, and frankly even some barristers would do well to remember that. So that's where the procedural side of costs can become quite important. Substantive issues that might lead to an award of costs can include running points with absolutely no legal basis, or trying to run points, or indeed refusing development on points where there's no evidence offered to support that view. Just one last thing to think about is that in making decisions on unreasonableness, an inspector is entitled, and indeed is told by the PPG, to look at the course of conduct over the whole of the process, including the planning application. So it doesn't just start at looking at the conduct in the statutory appeal. So that was the first limb. The second limb is that the unreasonable behaviour must have directly caused unnecessary expense. So any application, and I'm going to come on and how you make applications in a moment, must clearly demonstrate how that unreasonable behaviour resulted in the expense. Direct expense can extend to, for example, the time spent by parties in preparing for the appeal, including the use of consultants to provide technical detailed evidence, time spent by experts preparing, etc. What it doesn't extend to are costs that are unrelated to the appeal or proceedings, or things like indirect losses, such as delays caused in obtaining planning permission. That would be an indirect expense and is not recoverable. So turning to the who and how of applications, who can apply? The appellant, the LPA, any interested party that has taken part in the process. And recall, as I said, the Secretary of State can decide that he can recover his own costs of these appeals too. The inspector may make an application of his own initiative. So just because your opposite party in an inquiry or a hearing doesn't make an application, it doesn't mean if you behaved unreasonably, you are home and dry. If you're looking to make an application, the when and how is outlined in the PBG. There's a hyperlink on this slide, which will take you straight to it once the slides are circulated afterwards. For certain matters, such as those resolved under the Householder Appeals Service or the Commercial Appeals Service, you make the application in writing when the appeal is submitted, if you're the appellant, or 14 days after the start date of the appeal, if you're the LPA. If you're involved in a planning appeal that's being determined on written reps, you make the application in writing no later than the final comments stage, unless the inspector sets a different deadline. There is an exception to this if it relates to the costs of a site visit, in which case you have to make it within 7 days after the site visit. If you're in a hearing or an inquiry, then whatever you do, you must make the application before the inquiry closes. It is good practice, if you know you're going to make an application, to make it in writing first in advance of the inquiry, draw the inspector's attention to it at the inquiry, and then supplement that with oral submissions where necessary. If it relates to something that comes out of or happens at the inquiry, tell the inspector before it's adjourned or closed. He'll hear your application, he'll hear any response, and then if you're applying for costs, you get the last word. If it relates to a matter that's been withdrawn, make the application within 4 weeks of the date of notification of what it is that's been withdrawn, the hearing or the inquiry, for example, and PINS has a special application form for that. And again, I've put the hyperlink on your slide. It is possible to make an application late, but you're going to need to show a very good reason for doing so. And of course, if you're making the application, whichever way around you're making it, then the person who's on the receiving end of it will get a chance to respond. Turning then to the award itself. Assuming you've made your application and you're successful, the inspector will issue a reasoned decision. So there'll be the reasoned decision as to why he's awarding costs, taking into account your submissions, and then there is usually an operative clause, which is I award costs to X. There's usually some standard wording. However, there have been some awards in recent years that have fallen down a little bit on the wording, so it's helpful to be aware of the following points. First, once the inspector has made his decision, it's for the courts to interpret it. You can't use costs proceedings to invite the costs judge to depart from the clear wording of the order. That came out in Maiden London Limited, which is on your screen. In effect, there were 3 appeals relating to overlapping costs. The cost award said that the costs would be recoverable save for common costs. The receiving party was arguing this meant that it should be allowed to recover the common costs in one of the 3 appeals, but not the others. So where costs were common, they could be factored into one of the appeals. The paying party said save for common costs meant common costs were not recoverable at all. PINS had issued a letter afterwards saying that it agreed with the receiving party's interpretation, i.e. that what it had intended by the award was that common costs were recoverable in one but not multiple, but not all 3 of the overlapping appeals. The High Court said no. Save for common costs is very clear as to what it means. It would be a stretched interpretation to argue for what the receiving party wanted. It also made clear that you can't look at ex post justification of the award. So in this case, PINS's note saying, oh yes, this is what we meant. That's not a permissible aid. Where, however, the costs award, particularly the operative award, is not clear, you're entitled to look at the decision accompanying the award of costs. What is clear is that the cost award should clearly specify what the Secretary of State considers the nature of the wasted costs to be. And that sounds obvious, but there are a couple of ways that this can go wrong. Scrivens is a particularly good example. In that case, the applicant had both at the appeal stage and indeed in the planning process leading up to that, dumped a huge volume of documentation on the appellant and the inquiry, much of it irrelevant, much of it unreasonable. The inspector made an award of the costs of the appeal so far as they relate to the quantity of the material submitted in those terms. And the admin court held, frankly, this was just too vague to be enforceable. In Mayor of London, slightly different way it can go wrong. The costs award provided that a full award of costs would be made, but then sought to limit that to the unnecessary or wasted expense incurred in the appeal process. And there were 2 issues here. The first was you couldn't put forward, or the Secretary of State can't make a full award of costs and then limit that. You make a partial award. The second point, more fundamentally, is that it confuses the award itself with one of the precursor tests, i.e. the unnecessary or wasted expense point. The court made clear it's the inspector, not the costs judge, who should decide what that wasted expense is. And again, the parties are entitled to understand what that is. If you want to challenge a costs award, it must be done by judicial review. There is therefore a suggestion, certainly made in London, that the 3-month JR time limit applies rather than the 6 weeks we're used to in the planning world. But as a word of warning, because even where the 2 tests for the costs award are satisfied, the Secretary of State still has discretion. It's going to be very, very hard to judicially review an award of costs. It's doable, but it's tough, and it's going to be damn near impossible to do it on simple irrationality grounds. So assuming you've got your costs award at inquiry and it's not appealed, how do you enforce it? Well, Section 255 of the Local Government Act, which I put on your slide at the very start, continues that the costs award may be made a rule of the High Court on the application of any party named in the order. Notwithstanding the archaic language of rule of court, basically you're applying to make it an order of the High Court. So with your successful award in hand, the 3 stages are: you try to agree your sums with other parties. The vast, vast majority of planning costs awards do tend to be settled by agreement. If you can't do that, then you make an application to the High Court for effectively it to hand down a cost order in the same terms of the Secretary of State. And once you've got that, you begin detailed assessment proceedings in accordance with CPR Part 47, which is the cost aspect of the CPR. And it's there, I think, that I'm going to turn over to Tom.
Thank you, Nick. So I'm going to talk now about Part 47, first of all, which is the chapter of the CPR, or the part of the CPR which sets out the procedure for carrying out detailed assessments of costs. And first of all, I think it makes sense just to start with some key terms which come up all the time in cost assessment proceedings, starting with detailed assessment proceedings. This means, straightforwardly, the process by which the party's recoverable costs are actually quantified by a cost judge. So it's just important to note that this is a procedure invoked where one party has been ordered to pay another party's costs, but the parties cannot agree between them the amount that is going to be paid. So it's an adversarial process involving the judge scrutinising the material and the evidence that's placed before the court and listening to submissions from the parties. It does not usually involve live evidence, although sometimes it does involve witness statements being filed in relation to some of the costs claimed. The key terms, or the 2 key terms really, are receiving party and paying party, which are used throughout Part 47. And simply enough, the receiving party is the party entitled to be paid its costs. In other words, the party in whose favour the costs order has been made. And the paying party, the corollary, is the party liable to pay those costs under that order. And the procedure in Part 47 can be found online. It's accompanied by a practice direction, also available online. It's a relatively straightforward procedural code. It's fairly user-friendly. However, as Rupert will come on to say, it is important that the procedure is followed very closely, and that you always have an eye in particular on what the practice direction tells you to do. There are also a number of forms which are annexed to the practice direction which set out how material needs to be presented to the court. And it's particularly important to try to comply with everything, particularly time limits, because of a number of sanctions which exist where parties fail to comply with time limits, and I'll come on to address those in just a second. Some key procedural points. The detailed assessment proceedings are commenced by the receiving party serving a notice of commencement and a bill of costs. And the time period for doing that is set out in Rule 47.7 by reference to when the particular order was made. Broadly speaking, it's 3 months from the date of the order. And the venue for detailed assessment in planning matters is the Senior Courts Costs Office, the SCCO. So the key documents begin with the receiving party's bill of costs, and this is essentially where the receiving party sets out its case, sets out what it wants to be paid. There are a number of precedents attached to the practice direction, which are available online, and the practice direction sets out very clearly what the bill of costs needs to do. First, it needs to have a title page, Secondly, it needs to include a brief description of the proceedings up to the date of commencement. And this, as I think Rupert will come on to say, is also very important. It's an opportunity for the receiving party to outline how complicated everything was, how much work was involved, and to set the scene for why the costs which they are claiming are what they are. And the bill also needs to set out the hourly rates claimed by each legal representative, and the details of any agreement relating to costs between the receiving party and representative. So, for example, it's common where a solicitor's firm is doing a large amount of work for them to apply a discount to the hourly rates or to apply a discount to each invoice, and it's very important to set that out clearly in the bill. And then the bill needs to set out the actual costs which are claimed, and it does so on the particular heads of costs which are set out in paragraph 5.12. And this includes time spent on documents, attendances on your client, and also attendances on your opponents and the tribunal itself. And the bill also needs to set out details of the disbursements which are claimed. And in the planning context, obviously, the big disbursements are going to be the costs of the expert witnesses who have provided proofs of evidence and given evidence to the inquiry, and also counsel's brief fees. Details of the expenses which are claimed. So the next key document then is the points of dispute, or PODs, which is where the paying party sets out its case in response to the receiving party's case. Now, they have 21 days to do that from service of the bill of costs. And again, the practice direction sets out exactly what the PODs must do and must contain. And the practice direction tells us that the PODs must be short and to the point, and again, follow the precedent which is actually annexed to the practice direction. And the PODs can either, the PODs must identify general matters or points of principle which need to be looked at and determined before the individual items on the bill are assessed. Such as, for instance, evidential issues or perhaps categories of costs which the paying party might want to allege actually falls outside the scope of the costs order. Obviously, they need to be dealt with by the cost judge before they start to look in detail at the items claimed. And the PODs must also then, in addition to raising these preliminary issues, identify specific points, specific objections to some of the costs claimed, stating concisely what is the nature and the ground of the dispute. And the paying party must, as well, in an open letter accompanying the PODs, it must state what sum, if any, it offers to pay in settlement of the costs claimed. And so this is how the procedure of Part 47 continues to make sure that the parties are constantly keeping the possibility of settlement in mind. And the final key document, at least as far as the parties are concerned, is the reply. So once points of dispute have been served, the receiving party has the option to put in a reply within 21 days. And the reply must be limited to dealing with points of principle and raising points of principle and making concessions. It must not contain general denials or any specific details or anything like that. And again, it must be in the form of the precedent attached to the practice direction, precedent G. And finally, it's important to just address the concept of certificates, which is a key part of how Part 47 works. There are three different types of cost certificate which can be awarded by the cost judge. The first is a default cost certificate, which can be made where a paying party fails to serve their points of disputes in 21 days. The second is an interim cost certificate, which is an order that the paying party pay an amount of costs to the receiving party on an interim basis before the assessment has concluded. Now, if you're acting for the receiving party, obviously you want to think very carefully about making an application for an interim certificate, because if your application is successful, it means that you will get paid a chunk of your money in advance and long before the assessment has actually concluded. And if your costs are large and the assessment of them is likely to take a very long time, this is a way to ensure that you're not left out of pocket for the money that you've spent throughout the duration of the assessment. It's important to note as well, though, that there's no automatic presumption that an interim certificate will be made. It's in the court's discretion, and the principles which the court takes into account when considering whether to exercise that discretion are set out in the case of Blakemore and Cummings, which is referred to on the screen. And the last certificate is a final cost certificate, which is the order that gets made by the cost judge after the assessment is completed, which actually orders the paying party to pay the assessed amount to the receiving party. I referred to the existence of sanctions for breaking time limits, and these are as follows. First, if the receiving party fails actually to commence detailed assessment proceedings in time, then the paying party may apply to the court for an order requiring the receiving party to do so. And the court may order that if the receiving party does not do so, it may be disallowed some of the costs which it would otherwise be entitled to. So it's very, very important to make sure that if you are the receiving party, you commence detailed assessment in time. Even if the paying party does not make an application for such an order, the court also retains a discretion if the receiving party doesn't start assessment proceedings in time to disallow part of the interest which would otherwise be payable. Similarly, if the receiving party fails to serve their points of disputes within 21 days, then the rules say that they may not actually be heard within the assessment proceedings unless the court gives permission. And also the receiving party may apply for a default cost certificate. And if that default cost certificate is ordered, that essentially brings the assessment to a close unless the paying party takes steps to regularise the position. So now we come on to some points of law which arise in the context of assessing costs. And the first question really is, what is within the scope of a costs order? And this is set out in section 51 of the Senior Courts Act, which tells us that the costs that the court can order a party to pay are the costs of and incidental to the proceedings. Now, those costs must arise actually from the litigation, the appeal itself. It can't arise from non-contentious work, but it does include pre-action costs if those pre-action costs are, properly speaking, to do with the subsequent litigation, or in this case, the appeal or the hearing. The way that this works out as a matter of law is by reference to the Gibson Principles, and these three principles come from the Gibson Settlement Trust case, which is referred to on the screen. And costs will therefore be recoverable if the following three things are satisfied. First, if the work in respect of which the cost is claimed was of use and service in the claim. Secondly, the work was of relevance to an issue in the claim. And thirdly, the need for the work was actually attributable to an act or omission on the part of the paying party. And that last one is quite important to bear in mind, especially if you're acting for the paying party, because it provides an avenue to attack costs claimed. Obviously, costs will not be, properly speaking, attributable to the paying party if the work in question had already been done before the paying party put in issue that particular issue. And so in the planning context, for instance, any surveys or reports which have been carried out or undertaken before a local planning authority raises a particular issue will not be recoverable, even if that material is subsequently used in the appeal. But if the work on those surveys and reports was actually caused by and happened after the paying party had put in issue the issue in question, then they will be attributable to the act of the paying party, and they therefore will fall within the scope of the costs order. But it's important to note, of course, that, as Rupert will come on to address you on shortly, just because work falls within the scope of a costs order as a matter of law does not mean that the costs of the work are reasonable or proportionate. And coming on to expert evidence, which, in addition to counsel's brief fees, is going to form, in most cases, the larger part of the bill of costs, the costs of the experts. It's important to remember that there's a very important distinction between expert and non-expert work. And the way that this is made sense of in the authorities is that the courts say that the cost of marshalling the facts on which expert evidence is to be based, those costs are not recoverable in principle. And it follows from that a receiving party cannot usually recover costs which are paid to its employees unless the employee's work was, properly speaking, that of an expert witness, that of an expert nature. And that is, of course, a question of fact and degree, having regard to the complexity of the work and the knowledge of the person doing it and their particular expertise, and whether it could have been done by a lay employee of the company in question. Or of course, the local planning authority. And something which arises from this is that the costs of company directors simply attending a planning inquiry will not be recoverable. Those are part of the costs of being a litigant, or actually of appealing the LPA's decision to get your planning permission approved. They're not within the scope of a costs order. And a useful illustration of this is what Mr. Justice Bingham, as he then was, said in Richards and Wallington and Monk and Co., where he said, I have no doubt that a great deal of work needed to be done, part of this perhaps being attributable to the difficulties of proof in which Richards and Wallington found themselves and various problems they had to overcome. But essentially, I think these two gentlemen were engaged on a factual exercise. They were certainly not independent experts. They were not, in truth, acting as experts at all. And in my judgment, these costs fall within the ordinary costs that a litigant must bear of digging out his own factual material through his own employees to prove his own case. Had outside experts been instructed to carry out this work, then it by no means seems to me to follow that it would in any event have been recoverable as a cost of the litigation. So there is that principle eloquently put by Mr. Justice Bingham. Just a couple of other points which come up in relation to the assessment of the costs of experts. It's notable that experts must, of course, confine their evidence to matters which are within the area of their expertise. And if they do not, if they stray beyond their expertise, then it is open to the court to disallow all or part of the fee that that expert is claiming on the basis of either relevance or reasonableness. And following on from the last point, if the expert's fee must not include the fee of providing ordinary professional assistance or services to their client, which is not, properly speaking, expert witness work. And so an example of this is an employed architect carrying out routine work in relation to matters concerning a planning appeal. If that work is routine and that architect is employed by the company which is the appellant, then that work cannot, properly speaking, be included within the fee that that architect charges, even if that architect then goes on to give expert evidence in the appeal itself. It's worth bearing in mind that if you are acting for the paying party, these are points that it can be worth attacking. It's important to scrutinise exactly what is claimed for the particular expert and exactly what is in their report. And if, in fact, the claim includes time spent long before the report has been written in the ordinary course of preparing the appeal or indeed the application, then it's important to attack that as being not recoverable in principle. And finally, just as an evidential point, where the expert's fees are considerable, then it is acceptable to put in evidence as to the market rate in order to justify the reasonableness of the costs claimed. And last slide, then I'm just going to say some things about how the assessment of experts' fees works in practice and of the costs of experts preparing proof of evidence in planning appeals. Actually, the requirements to justify or to provide evidence of the fees claimed are remarkably light in the practice direction. All that the practice direction says is that the bill of costs must be accompanied by written evidence as to any disbursement exceeding £500. Now, in practice, what this means is that the receiving party needs actually to put in the proof of evidence, as well as the expert's fee note, and also some sort of an explanation, perhaps, of the work that was involved in generating the proof of evidence and giving the evidence. And although the evidential requirements are much less stringent than the requirements for solicitors' costs, the evidence still needs to be sufficient for the court to be able actually to assess the reasonableness and proportionality of the amount claimed. In other words, the court needs to be satisfied, as a matter of fact, about what the expert actually did and how long they spent doing it, before it can then start to ask questions about whether the costs claimed for that work are reasonable and proportionate. And in practice, commonly what happens is that the cost judge will look at the proof of evidence, they'll have read through it ideally, and they will hear submissions, and then they will use their experience, they will bring their experience to bear and form a view about how much time should reasonably have been spent actually on preparing the proof of evidence and preparing to give evidence at the inquiry. And those principles are discussed much more in much more detail in one of the decisions that's come out of the detailed assessment in the Deutsche Bank case, which, as I said, Rupert and I have been involved in. At that point, having mentioned Rupert, I will turn off my microphone and camera and hand over to him to address you on the important stuff.
Hello, everybody. I'm going to be addressing you for the next 10 to 15 minutes on the quantum of costs. Costs themselves are all awarded on two bases. You either get it on the standard basis or you get it on the indemnity basis. Where an order is silent as to cost, that means the standard basis. And the basic rule of thumb is that if it's the indemnity basis, you as the receiving party are much more likely to get a level of recovery close to that which you've actually spent than if you were having your costs assessed on the standard basis. Now, the reason why standard basis and indemnity basis matter is because of the difference between the two. Now, so far as costs are concerned, you've got two means of assessing costs, and those are the concepts of reasonableness and proportionality, which I'm going to come on to. You've then got 2 points of challenge. The first is incurral. In other words, was it reasonable and or proportionate to actually incur the cost at the point that that cost was incurred? And that applies to solicitors just as much as it does to any expert or disbursement. And then the next one is amount. In other words, if it were reasonable or proportionate to incur that particular item of cost, was the amount that has been incurred itself reasonable or proportionate, depending on the test. And the final limb is doubt, where the benefit of the doubt lies. Now, when you're on the standard basis, as the slide shows, where you've got the benefit of the doubt, it's going to lie in favour of the paying party. Now, what that really means in practice is that when the cost judge is exercising their broad discretion, coming to a view as to exactly that which is proper and reasonable and proportionate to incur, it's always going to be far more draconian insofar as the standard basis is concerned. So on the standard basis, you've got both reasonableness and proportionality engaged. You're looking at both incurral and amount, and doubt is resolved in favour of the paying party. And you see that embodied on the slide in front of you. The next basis, as I mentioned, is the indemnity basis. Now, when you're looking at the indemnity basis, you're again looking at incurral and amount, but you're not looking at proportionality. Proportionality falls by the wayside, so you're only looking at reasonableness. And again, I'm going to go on to explain why that matters. And any doubt is resolved in favour of the receiving party. Now, and again, this is prosaically speaking, but in my experience, you're going to find that the difference between an award on the standard and indemnity basis is worth about 50%. If you can possibly push the indemnity basis, you should. The simple reason being that proportionality plays a huge part in the actual quantum that's recoverable in detailed assessment proceedings. Now, looking at reasonableness for a moment, what you're doing when you're looking at reasonableness is you're making an evaluative assessment of the item of cost itself, and there's no hindsight applied. So what you're doing is you're placing yourself in the shoes of the reasonable receiving party in the particular circumstances in which they found themselves, and asking yourself, was this item of cost reasonably incurred? So again, by way of example, if we're talking about the instruction of experts, at the point that the expert was instructed, was that a reasonable decision to make given the facts and circumstances known to the receiving party at that given point in time? And the next is going to be reasonable in amount. If it were reasonable to instruct the expert at that point in time, was it reasonable to instruct the expert either on the terms that they were instructed, or given, if the expert was looking for a lump sum for a given product, was it reasonable in amount to agree that in terms? And again, reasonableness is a relatively, say, low bar, but it's not nearly as high as proportionality is concerned. The short point is the vast majority of decisions that you make or your clients make are going to be reasonable in the circumstances. You really find reasonableness biting on what I describe as items of costs that are own party costs. So was it reasonable for you to be endlessly communicating with your client in the manner in which you did? Or if you're anticipating an argument that's yet to be put, was it reasonable to incur costs in respect to that argument, given that it wasn't put and indeed was not put? But again, reasonableness, and I'm going to move on to the next slide, in proportionality to talk about how it's actually made manifest, is not something that ultimately is going to involve a reduction of more, I would say, than 20–30% at most of what it is that you're going to be taking home on the quantum of the assessment. And proportionality is an entirely different kettle of fish. The reason why it is that it applies hindsight, and it asks you to evaluate the cost against the product. And you'll see on the slide that costs incurred are proportionate if they bear a reasonable relationship to sums and issue, value, non-monetary relief, complexity, additional work, and things like wider factors. The reason why Tom mentioned earlier when he was going through the format of the bill, that what you'll often find the receiving party doing in the narrative is drumming up to the greatest extent they conceivably can the complexity of the issues, because they've got one eye on proportionality when it comes at the end of the day. And the reason why they do is because of the way in which reasonableness and proportionality, and again, it's only on the standard basis that they're both engaged, actually implies in practice. Detailed assessments are, in the main, relatively routine and often very boring. You're going through items of costs, same, often standardized challenges, and you do that in a chronological manner. So you go through those costs, and what the cost judge will be doing is looking at each cost and asking himself, is that reasonable? And we'll go through, and at the end, having done so, we'll then aggregate the costs into their composite parts. You'll have a certain number of costs in respect of certain experts, certain number of time costs for a solicitor for a given period. The judge, when applying proportionality, so we're looking at the standard basis assessment only here, is then going to look at the product and ask himself, with the benefit of the hindsight, so knowing developments as they actually occurred, is the product worth the cost? To give you an example, you might find a solicitor has spent a large amount of money putting together a draft witness statement for a witness that wasn't actually called. It's going to be difficult to get that home on a proportionality basis. You equally might find an expert who's opined on a particular issue which, as it turned out, was totally rendered irrelevant because of a particular decision. Again, that's going to be difficult to justify on a proportionality basis. So you can see with that in mind why it is that proportionality does end up lending itself to a much reduced figure in terms of recoverability when compared to reasonableness assessment. So that actually explains what the twin bases of reasonableness and proportionality are. I'm just going to go on to some tips for the receiving party and the paying party, but before I do, I'm just going to dwell a little bit more on the actual process. At the stage you're going to come to a hearing, you've got the bill of cost, which is akin to a particular claim, you've got the points of dispute akin to defence, and then you've got the replies, which are, of course, replies. You're going to have isolated the principal issues, and one of the big things that you find people making mistakes on when it comes to the quantum of assessment is that they don't actually devote proper time for the big ticket items. There's no point expending a great deal of energy over a single attendance note that's worth 6 minutes for a solicitor's time. Why not focus on the hourly rates that are going to apply throughout the bill? An assessment, bog standard one, so not like the one that Tom and I have been involved in, you might be thinking about probably 2 or 3 days for something like £500,000. Now what that means is there's a huge amount of ground to cover in a very short period of time, and often that ground is pretty arid. We're not talking about points of law. And the way that that finds itself made manifest in the cost judge's decisions, that decisions are made throughout the day on every single item of cost as you move through the bill, and the judge will tend to, over time, get a much greater feel for how it is that the receiving party have conducted the litigation. Now, the greater the feel they have, the less they're going to want to take into a document. Again, if you think about it in its narrowest form, you as the paying party are going to say, right, I can see from your bill of costs that you've spent 7.5 units on this email to the client. Now, of course, as the paying party, you can't see that. That's privileged, so the judge gets it up in front of him, the representative of the receiving party has it in front of them, and they then have a discussion as to why it should take 7.5 units given the product. Now, by lunchtime on day one, that exercise has really run its course, and the judge will start making broad brush reductions based on their experience of the cases they've seen it. And that goes into some of the tips that I'm set out on the screen as to what it is you should be doing. So far as the receiving party is concerned, when you're drafting the bill, what the bill has on the left-hand column is numbers from 1 to however many it takes, and allied to each one is an item of cost. Now that item of cost is going to be time spent doing a particular thing, and you'll have a separate set of schedule for time spent on documents. One of the slides as I'm going to come on to is the importance about getting a cost draftsman involved. Now I don't mean in any way to diminish the importance of solicitors in this process, but frankly, as a solicitor with an expertise in planning, your time is much better spent elsewhere. What a cost draftsman will do is take over the solicitor's files, and then we'll compile the bill, and in doing so, we'll index the bill to the individual item evidencing the product of the time spent. Now, if you don't have that, and that process hasn't been undertaken, a judge is going to put the benefit of doubt against you at every single stage because you haven't properly evidenced it. Every call needs an accompanying attendance note. There's no point putting in that you've spent 15 minutes speaking to so-and-so if you haven't actually got an attendance note evidencing the substance of it, because again, certainly on the standard basis assessment, it's all about a matter of just endlessly pushing water uphill. So the more evidence they have, the better it's going to be. The next point to bear in mind is the receiving parties. If you don't ask, you don't get. At the stage of the meat of the assessment, it's the end of day one, everyone's feeling jaded. You're going to find that there's going to be a bill of costs that says, in August, we had 21 separate calls to the client. All of them are routine calls, in which case we don't need to provide evidence. The judge is going to look at that 21. We'll look at the paying party who'll be offering 4, the receiving party will be prepared to accept 17, and the judge is going to say, right, let's call it 11. So if you don't ask, you don't get. The more you up the limit, the more you're going to get a judge on a broad brush finding favour with the position that you're taking. Target your energy for the big ticket defensive points. So that's hourly rates, that's disbursements, and that's work done on documents. I mean, ultimately, you're going to lose 6 minutes here or there, but there's no point losing sleep over that. But hourly rates do matter, and you need to make sure that it's properly done. And by that means you've actually got to have evidence of the experience, and you need to have cross-referred that to the complexity of the case to justify the experience of the fee earners and time. Counsel's fees. All solicitors on listening to this seminar need to have evidence the fact that they have quibbled with counsel's fees. I'm not doing this, not doing any favour to my particular branch of the profession in saying that. But where you've got a lump sum for a given silk in the tens, even hundreds of thousands of pounds, there needs to have been some form of email in which the solicitor says, can you justify this figure? Or what is this figure based on? Or what is the hourly rate that's being applied to this? Otherwise, if you just wave it through, you're inviting an argument from the paying party saying, well, why didn't you inquire? Why didn't you interrogate? The reasonable litigant with one-eyed proportionality would have done so. Guideline hourly rates, the case there at the bottom is one for you to just have in mind. Everyone gets hugely exercised and excited by guideline hourly rates. This is a case that says it's, if not quite irrelevant, not far from it, albeit that it's important to note that they are being updated to the modern day, because the rates themselves were last updated in 2010. So far as the paying party is concerned, always attack duplication. Solicitors act in packs. You're always going to have your partner, you might have 2 partners, you might have 2 or 3 associates. Now, because not every one of them is going to be doing a given activity, they know that they can't, because some activities require a junior fee earner. You need to be attacking duplication, because there will be an enormous amount of correspondence between them. And you're going to be saying, well, if you've got a junior associate emailing 2 partners about a given issue, both of those partners should not be recovering cost for it. So always be aware of duplication. Attack disbursements, particularly in a planning context, they're always going to be the big ticket ones. You know, you get many prestigious counsel out there who will provide excellent value for money, fantastic service, but ultimately that's not the question. The question is, what would the reasonable counsel who can do the job adequately actually demand for the job? You'll often find in a bill of costs things that shouldn't be there. And by that, the vernacular that's normally used is non-progressive items. So things like, you know, issues about client care information or correspondence about retainers, that kind of thing. That is not something that is relevant to a paying party, because it's not necessary for the progression of the litigation. Always demand evidence of products. Again, we're particularly product focused on proportionality. So where you've got, you know, a particular line in a counsel's fee note saying advice generally, you're going to say, well, what was that advice? Where's the evidence of that advice? Was it by email? Was it by phone? Why isn't there a corresponding entry in the solicitor's notes? If there is, where's the attendance note evidencing what that advice is? You really want to focus it on products as much as you can. Hourly rates, focus them both on the solicitor's hourly rates, but equally do it on the expert costs. The courts have got very little to work on so far as what is reasonable proportionate for an expert's hourly rate cost. So what they tend to do is they tend to refer back to the guideline hourly rates, work on the assumption that the expert's going to be akin to a partner, and use it on that basis. But of course, there are going to be loads of planning experts out there that are going to be charging a lot more than 2010 grade A rates are. I mean, for central London, they're 400 odd pounds. I mean, it's high, but you're going to get lots of planning consultants doing more than that. So you should be using the guideline hourly rates as a means of attacking those expert fees in turn. Always try and attack the retainer. You're never going to be able to see it as the paying party, but the judge will see it, will look at it. And the point you particularly want to make is to ensure that the scope of the instruction, so far as the retainer is concerned, is consistent with the costs that have been incurred. You often get solicitors that have been instructed to deal with minor issues at the outset. The retainer is based on that. It then snowballs, but at no point is there any thought to actually change the terms of the retainer. Tips for both parties. Always make offers. There is, I mean, arguing about the costs of the substantive action are, you know, for lots of people fairly tangential, because, you know, either the horse is bolted or the horse has been restrained. But if you don't make offers, you're going to find yourself, as I'm going to show on the next stage, expending money arguing about the costs of the substantive action. And that really is the stage where you're so far removed from what actually mattered, that you need to bring that to a close as soon as you can, because it is simply throwing good money after bad. So you should always be making offers. The next point is, when it comes to costs, it is a specialist area, and there are 2 points that flow from that. The first is whoever your counsel that acted on the substantive matter, with the exception of probably Tom, Nick, myself, maybe 1 or 2 other practitioners, but there aren't many, should have nothing to do with the cost assessment. You need to be at the outset, when you are claiming your hundreds of thousands or facing a claim of 100,000, identifying the counsel you want, talking to the specialist cost counsel that you're asking, which cost draftsman they recommend. And the reason why I go on to cost draftsman is the point I made earlier, which is about diminishing returns for time. Specialist planning solicitors will charge costs which are entirely consistent with their specialism, but the idea that they can then charge the same rate of costs when having bog standard arguments about quantum and expect to recover it is totally unrealistic. And what these cost draftsmen do, and they'll charge between 115 and 150 pounds an hour, so they're very cheap comparatively at rate, is they'll compile the bill. And then when you come to the substantive hearing, you're going to get Tom, Nick, myself dealing with big ticket items at the outset. We'll deal with hourly rates, we'll deal with proportionality, we'll deal with indemnity issues, we'll deal with the particular reasonableness of instructing an expert at a given point. And then having dealt that, we'll hand the line by line assessment back to the cost draftsman. And again, most of that is due to economy and expediency, ultimately. There's no point paying us our hourly rates when you've got a cost draftsman who is much cheaper, who's composed the bill, who can actually have the bog standard argument about whether it was reasonable to spend 3 units on a phone call or not. So it is actually the point at which you move away from your specialist planning team to a specialist cost team. And the final point is just about costs of the assessment proceedings themselves. As I say, this is the point where you really need to be looking in the mirror thinking, should I be throwing good money after bad, arguing about the costs of the assessment procedure itself? The default position is that the receiving party is going to get their costs. So if you are the paying party, you either need to be targeting massive reductions, but be realistic about it, because if you're not going to get those reductions, you're going to end up paying the receiving party their costs of the costs of the assessment proceedings, or you need to be using offers. And the whole basis of CPR 4720, which deals with the cost assessment proceedings, is all about incentivizing offers. It is your protection, but it's also the means by which you can start funneling your precious resources on things that actually matter, rather than, though they might not thank me for it, actually lining Tom, Nick, whoever the cost draftsman's pockets in turn actually is. And at that point, that brings me to the end of my stint. So I think I'm going to hand back to Tom, who I think is going to be chairing us on some questions.
Thank you, Rupert. I have been keeping half an eye on the questions that have been coming in on the Q&A tab, and I think I managed to compile a list. Apologies if I miss anyone out. The first question to look at, I think, is a question about timing. And this question has just been amended, actually, but I think I've got the gist of it, which is that where a costs award is made, or a cost award is made sometime before a bill is presented to the local planning authority, who object on the basis that the costs are considerably higher, not directly attributable to the appeal, but no application to commence assessment, I think, has happened following that decision. A year has passed. Is it now too late to start detailed assessment? Nick, is that something you can just take on?
Sure. I mean, effectively, this is asking if there's some sort of limitation period on an inspector's award of costs. I can't see any basis for one in the legislation. Can't think of any in the Limitation Act, and courts would be highly reluctant, I think, to make one up. So subject to the fact that I've not been asked that before, and therefore please don't rely on this by way of advice, I don't think a delay of a year or so is going to make it too late. I'm afraid to say no, I don't think that's going to be an argument that's run, unless anyone wants to correct me.
Thank you, Nick. And then there's another question about battles with local planning authorities over the year about the amount of costs. And the question is, if the claim is put in for X amount of costs of fighting the appeal and the council queries the amount, is the receiving party entitled also to claim for the time taken in resolving the final amount to be paid in negotiations? Rupert, as you've just touched on that in your presentation, do you want to pick that up and run with it?
Sure. What tends to happen in normal circumstances is that the point at which you've got your costs award is the end of the cost of the substantive action. Now, from that stage, you've got a slight twilight period before the cost of the detailed assessment. Well, change that. Before the detailed assessment itself is actually set down and heard. And you quite often get and disputes. Now, the detailed assessment procedure starts when the notice of commencement is served, and where you've got costs that incurred between the two, principally speaking, they seem to sit fundamentally nowhere. But the short answer is, when you're actually doing your negotiations, you should be including within that your time, because you're working on the basis you're going to come to a negotiated settlement. With that being so, it robs you of your chance of serving a notice of commencement and then recovering the cost under the alternative head of the cost of the detailed assessment. So, you just need to make it abundantly clear that any negotiated fee is going to include your costs of dealing with negotiations, and then consequently ensuring that your costs bill either has provision for it, even if it's going to be prospective provision, or that you update it time to time to take into account the costs you've incurred in dealing with negotiations. Back to you, Tom.
Thank you, Rupert. The next question is this: can an appellant reasonably include counsel's costs at a hearing where an award has been made, but where an appellant chooses to use counsel as well as witnesses to present their case? Might it be argued that the presence of counsel at the hearing is not necessary, and that this is a luxury that the appellant should pay for itself? Nick, can you answer that question in relation to the difference between counsel at hearings and counsel at inquiries?
Sure. It's a bit of a dodge, but I think it's going to be a very fact-specific question. Whether to instruct counsel, and if so, the seniority of the counsel, is going to depend on analysing a number of factors in any specific case, including things like the amount or value of the property, the importance of the matter to the parties, its complexity, difficulty, novelty, and obviously planners familiar with this, familiar with the fact that those sorts of things would ordinarily, if it was, say, complex, novel, very expensive, one would ordinarily expect that to be more of an inquiry matter than a hearing, where you've basically got the inspector who's meant to be taking the lead. So there is an argument that counsel might be unnecessary, but if, in a post-Roswell world where we're trying to, or where PINS is trying to move a lot of things to hearings rather than inquiries, it might well be you end up with big, complex developments being decided in the hearing context, in which case it might be perfectly reasonable to instruct a barrister. So I'm afraid a bit of a dodge, but as say, fact specific. Certainly an argument you could make, though.
Thank you, Nick. The next question, Nick, perhaps you might also be able to deal with this one. It's another procedural question, which is, if an appellant has been awarded costs because the counsel did not substantiate the single and only planning reason for refusal, can it be taken that the appellant, the receiving party, can reasonably request reimbursement of costs of lodging the appeal in the first place, given the appeal was not necessary?
Depends on what is meant by didn't substantiate. So if the counsel ran a case, put forward some evidence, and it was just rubbish and they got steamrolled, then not necessarily. But if, say, the counsel's one reason for refusal, it couldn't put forward any sort of expert or any expert evidence on a particular point, and either produced no evidence at all, or someone without any sort of, who is never going to be able to make a particular fist of fighting this, then yeah, there's definitely an argument that should be able to reclaim the costs of the statutory process. One of the reasons underlying this, as I said in my talk, one of the reasons underlying the cost jurisdiction is to make sure that local authorities don't refuse planning applications on utterly spurious grounds. So yeah, it's certainly possible.
Thanks. A question which has cropped up a couple of times is about the hourly rates that can be claimed for local planning authority planning officers. Given that they don't usually have an hourly rate because they're employed, how do you calculate for the purposes of assessment what they're going to be paid for their time and what is reasonable? Rupert, is that something you might be able to address?
Yeah, the principle is that if you as a party have incurred costs on your own employees, if they do one of two things, obviously one is in-house legal services, and the other is that they're actually providing evidence or product which would otherwise be done by an expert, they're in principle recoverable. You always get issues about what rate they should have, because I mean ultimately they're paid by a salary, and it begs the question of whether you should be kind of breaking their salary down and then adding in overheads to try and find an actual nominal rate for them. These arguments are often made by paying parties, and courts have got very little sympathy for them. What you should really be doing is identifying the minimum cost of that employee, which is normally going to be salary divided by number of months. Include within that things like pension contributions. I mean, you want an overall cost to which you need to be adding an uplift, which is going to be reflective of your overheads. Then cross-refer that to something like the guideline hourly rates. You're always going to be beneath them. Again, the vast majority of state emanations are always going to end up at about £100, £150 an hour, even if it's in-house legal services, let alone in-house employees that are doing expert work. You're going to have to anticipate the argument from the paying party, but I've run it as many times as I've been defending it, and every single time the judge looks at you with a raised eyebrow and says, Mr. Cohen, the guideline hourly rate says this. They're trying to seek £100 for in-house solicitor, or their in-house expert giving evidence comes in at £220 an hour. That's infinitely cheaper than your costs, or infinitely cheaper than the guideline hourly rates. Basically, I'm deciding the point against you. So I prefer the approach where you get total cost of individual divided by hours to give some form of hourly rate, add an uplift for overheads, but you basically benchmark it against guideline hourly rates plus 25%, call it, for inflation. The argument is a fact of life, and every single judge looks at you with a blank face if you're acting for the paying party and a raised eyebrow and encourages you just to move on. So there's no short and sharp answer to it, but I wouldn't get overly troubled by the machinations how you get to the figure. But if it's less than the guideline rates plus 25%, or appreciably less than their expert who covered the same turf and your expert won, I wouldn't get too exercised about the prospect of reduction.
I think it's also worth pointing out that if the paying party thinks that the costs claimed by the local authority are way above what they would have got if they'd gone out to the market and got a private practitioner, if the paying party can put in evidence of that, then that's something that might well be taken into the cost judge, who might well dock some money off the hourly rates claimed for the local planning authority. It's all about the evidence, really. Fine. We are tight on time, but let's just try and slot in one or two more if we just run over slightly. Nick, perhaps I can point this one to you. Is it reasonable in a redetermination appeal for a party to introduce wholly new evidence? So would producing a landscape proof, for instance, for the redetermination appeal when one was not produced for the quashed appeal be reasonable?
I mean, proofs are always only produced for the appeal itself, for the appeal, inquiry or hearing, because that's sort of a proof of expert evidence. But if you're talking, say, an LVIA assessment, it's, again, much like my last question, I'm afraid it's rather going to depend on the facts of the case. So, planning inquiry is basically a de novo hearing, and new issues may be raised. So it's perfectly reasonable for a developer to introduce evidence to deal with the issues that have arisen on appeal, even if they were separate to what it thought were the issues on the planning application. So you've got to look at the circumstances surrounding it. But if you're an LPA dealing with, say, someone who wanted to just change one pavement slab, and for what, terrible example, but that needed plan permission, you said no on the basis of landscape and visual impact, and they didn't produce an LVIA report, then if there was no way that it was ever going to have a landscape or visual impact assessment, then arguably it is unreasonable to refuse on those grounds. And if they've had to adduce a new landscape and visual report to say changing one slab of the pavement is going to make no difference, then yeah, it's reasonable and you could be in trouble. But if, say, your development is a 2,000 metre tower in an AOMB and they didn't produce a landscape and visual impact assessment, then A, it's perfectly reasonable to refuse on those grounds. The fact that they then argue it's reasonable for them to introduce a LVIA for the appeal hearing, but if you're a local authority and the costs award has been made, you're perfectly fine to argue, well, it was so obvious and so obviously going to be an issue that they should have done this before at the statutory, at the LPA application process. The fact that they didn't means we shouldn't be liable for the cost of them producing it now, late, when it was perfectly reasonable for us to have refused it on, LVIA grounds when it's 2,000 metre tower in the AOMB. So again, case specific, I'm afraid, but it's not something I'd automatically rule out.
And final question, perhaps, and this is actually probably a very good place to leave it, given that this is the end product of what we've been talking about. For everyone, in your experience, even with a full award of costs, do you find that it's still true that on an assessment you are likely to receive only 60% of the cost claimed? To which the answer is, well, there's no rule. It depends on what you're claiming within your bill. But it is likely that your costs are going to be reduced to some extent from what you've claimed. But I don't know, Rupert, in your experience, as a rule of thumb, can you put a percentage on it?
I mean, conventionally, what we used to say before proportionality rules changed in 2013 was indemnity basis, you'll get home on 80%, standard basis, you'll get home on 60%. Now, if you get it on the indemnity basis, you should still be getting 70 to 80%. If you get it on the standard basis, anywhere between 40 and 60. I mean, if they decide that it's proportionality is a reason to knock the cost down by 20%, because it wasn't as complex as your cost suggested it might be, there's not much that can be done. So, you know, the rule of thumb's got a place, but these days it's you know, all retained solicitors retained should expressly state that, one, there is no rule of thumb, and two, we can't possibly guarantee that you're going to get an appreciable amount of your cost back in assessment. I mean, that's what retainers have changed dramatically in the last 5 years to take that into account. So they used to say 80%, 60%, but these days I'm not sure we can.
And I suppose it follows sensibly from that if you want to knock someone's costs down by a lot, you should instruct specialist cost counsel to go and argue it. And similarly, if you've got a ludicrous cost bill, sorry, not ludicrous, high cost bill that you want to defend, again, you should instruct specialist cost counsel to go and defend it. Anyway,
so before we just because it follows on from something that Rupert said, one of the questions we were asked is, does proportionality apply, or what's the basis for proportionality applying in the cost world? And that's answered by the Maiden London Limited versus Ruddick case that I refer to on my slides that will be circulated afterwards. So yes, it very definitely does. And we've got a High Court case confirming that.
Thank you. So I think then it just falls for me to thank the other panelists for their time and their presentations, and to thank everyone who's attended for coming and listening to us. Thank you for your very helpful questions. I hope we've tried to answer as many of them as possible. And there are a couple of questions that really, I think, probably would have needed more time than we have, in which case, of course, please do get in touch and we'll have to take a look. But on that note, I will wish everyone a good evening and remind everyone that a link will be sent out after the webinar, which will enable you to watch it all over again, should you feel compelled to do so. Have a lovely evening. Thank you very much.